Hello, I'm James.
And I'm Liv.
This is the Criminal Maze podcast.
And today we'll be talking with the judge, Tan Ikram, about the criminal justice system through his eyes.
Thank you for coming along to talk to us today.
Pleasure.
The podcast series, we're looking at a fictional character from the start to the finish of the legal journey. And being a judge, we thought it'd be fantastic to speak to you to find out a bit more about what you do in the process in court.
Right.
So I think if we start at the beginning, why did you become a judge?
Well, I was a solicitor, in fact, in these parts for many years, and I'd go to court every day and I'd make the argument. Sometimes I'd win, sometimes I'd lose. Sometimes I'd think, why did you make that decision? I don't get it. Sometimes I'd just think it was plain wrong. And of course, I had my own view, and I thought to myself, I can make those decisions, and I think I can make them well. I was also very conscious of my own background in those days, because there weren't many Asian solicitors when I first started, and I was probably the first in town. And I also saw a bench which was incredibly middle class, and the Slough magistrates were often terribly posh business people. And I also thought, do you know what? I don't think like them. And I thought I could add something different. So that's how it was all sparked.
Can I ask, given that you didn't see yourself necessarily reflected in the bench in front of you, where did that confidence come from to think that you can do, as you said, you can make these decisions and perhaps make them better?
I'm not going to pretend I had loads of confidence in those days. It was a really different time then. I mean, we're talking about the late 80s, the last century. And, you know, times have changed a lot. I think when I applied, I can't honestly say I did it with lots of confidence. But I had already been dealing with parking tickets, because I became a parking adjudicator in London. So it was a very gradual build-up of confidence, if I can put it that way. And I thought I could do that reasonably well. I ended up dealing with regulatory cases on the Nursing and Midwifery Council. So by the time I applied to become a judge, I think I, by that stage, got enough confidence to apply for it. But I think confidence is a real issue. I think for a lot of lawyers, they think, it's not for people like me. That just isn't true.
And can you remember the process you went through, the selection and application process?
Well, in those days, it was slightly different than it was now. They hadn't invented the Judicial Appointments Commission. And I went through the Department of Constitutional Affairs, I think it was called then. And so I filled in this book, and I think I had to give them 6 referees. And it was a different process in those days. And it was a whole day. And I think I sat an exam in the morning. They call them qualifying tests now. And then there was a role play, then there was an interview. And then quite a long time afterwards, they let me know. And it certainly felt like quite a long time after. As I say, it's very different now. But that was in 2002.
And did you shadow another district judge in your training?
Yeah. Judges hit the ground running. It's your experience as a practitioner which gets you there. And if you've evidenced the competencies they're looking for in the exam, in the role play, in the self-assessment, I mean, you've ticked the boxes already. There is an induction course, which you go on, which was a week long in those days. And then you went and sat with a judge, and I sat with Terry English for a week at Reading. And then you were appraised. So it was quite a gentle introduction, but the assumption was that you were kind of already there because you were a practitioner in the field.
And when you talk about those competencies, what qualities and experience do you think a person has to have that makes them a good judge?
Well, the Judicial Appointments Commission publishes the actual competencies they're looking for. But I can only speak for myself. You've got to know your law. That's a given. But I think the real thing is being able to communicate with people. People come in frightened. Some people have health issues, mental health issues. They may lack confidence in the criminal justice system overall. And the real function, certainly at the sort of work I do, is getting people to participate. It's about making sure you can get the best evidence. It's about making people feel comfortable. A lot of people are not going to be legally represented. And so it's creating that environment. And that, I think, is about understanding people, understanding communities, and engaging with people.
I think with the background of representing defendants in court helps with that, because you are faced with people that from lots of different backgrounds, and you are in a room to talk to them, trying to gain their confidence and start communication with them.
Well, solicitors are really good at that, because that's what we do. We build relationships with our clients, and I think that's what makes solicitors particularly good judges.
Did you miss the advocacy when you started?
I did. There was some really weird. So if you're a partner in a law firm, which I was at the time, your phone would be ringing day and night. Your clients would be ringing you up at 3 a.m. saying, "I'm nicked." And then you become a judge and the world changes. That manic duty solicitor type environment in which you operate sort of dies overnight. It's different. I'm not saying it's better or worse, but it's certainly very different.
It's funny, we heard that in an earlier episode with a barrister who was a solicitor, higher rights solicitor, then went to the bar, and he said that as soon as he entered joined chambers, his work-life balance improved so much because he wasn't receiving the phone calls and late night working.
It's chalk and cheese. I mean, if you're a judge, you don't have those 3 o'clock in the morning duty solicitor calls, staying up during the night, giving advice, and then being in court in the morning. It's a very different work-life balance.
Did you find it had an impact on your the colleagues, the work environment that you had been used to working in as a partner, and you had this group of people around you that would be as invested as you were in the work, and then working as a judge is a very different working environment, I would imagine.
It can be very collegiate. I mean, my first full-time appointment was in Camberwell, and I think we had 4 or 5 judges there every day. And so we did go into each other's rooms and talk. We did bounce stuff off each other. You never felt alone. Some of my judges, because now I've got a leadership role, will be at courts by themselves, which I think can be a very different environment. I was lucky. And I was also very fortunate to have really, really good colleagues around me. Whenever you do something new, you inevitably have uncertainty, however confident you are. That's natural. But I felt that my colleagues were able to sort of always say, "Well, what do you think?" And you'd give your view, and they'd say, "Yeah, we'll go with your instinct." And that gave me a lot of confidence.
Do you think that kind of working relationships that you were afforded at the start of your career as a judge, has that been able to be maintained within the profession, or do you think over time that's become more difficult?
In what sense?
I mean, as being a judge, and the feeling that you have of working in a collegiate sense, has that changed over the past 20 years?
No, I don't think so.
Mm-hmm.
If anything, I think the advent of technology and the extension of Zoom meetings and email, there's now a natural sort of communication across the country, which I'm not sure there probably was 20 years ago. The world has actually become smaller, not larger.
If we look at your day-to-day role, so can you talk us through what happens from the moment you turn up at court?
if I'm sitting in court, I mean, I have quite a varied role. Because I'm the Deputy Chief Magistrate, I have a sort of pastoral role, a leadership role, looking after I think we've probably got about 130 salaried judges across the country now. If I'm in court, I hope I will have been sent some papers. Not always the case. And then there's an ability to get on top of papers and sort of really identify what the issue for that day is going to be. And then I always try to be prompt in court. I think it's really important to say you're starting on time, even if the rest of the world isn't ready. And I think courtesy is really important, dealing with everyone with respect, and just helping get to where you want to get to, which is what happened if it's a trial, and trying to ensure justice for everyone if you're dealing with sentencing. A day could be packed with trials. A day could be a large number of prisoners who were arrested yesterday and are being brought before the court. It could be up to 30, 40 cases where you're dealing with people who are pleading guilty or not guilty and the early stages of the hearings. I also deal with terrorism cases. I'm also a specialist judge in extradition, which is something completely different. And those really are very different to criminal hearings because you're really dealing with issues of human rights often, and the provisions of the Extradition Act as to whether somebody should be extradited to face trial abroad. No 2 days are the same.
Do you have a preference between a list of first appearances or a trial?
I don't think I do have a preference, no. I think it's the variety of the job that's actually very attractive. It's great sometimes to go in and do short trials. On other days, for example, in extradition, you see, we have to then often go away and write written judgments. And so there's a different level of perhaps intellectual input simply because of the complexities and uncertainties of the law sometimes in relation to extradition. Whereas if you're doing short cases where people are coming to the court for the first time, it's a very different skill set. It's a very different atmosphere in court.
And when you were talking about, you mentioned earlier, hopefully you'd have papers given to you at the beginning of the day. If you have a matter that is a terrorist incident or an extradition case, would that be something that you would be able to prepare for in any way beforehand, or is it the same kind of process that you'd be expecting?
Oddly enough, those are the cases where you will have the papers, because they don't tend to be volume-led. Whereas it's your everyday crime from the local police station where you're more likely to have issues with paperwork. But you know what? You get there, and that's part of the skill. If you don't have all the papers you need, you get them. You get them from prosecutors, you put cases back.
It seems like the way that you're describing it, there's so many different gear changes throughout the day. You've got these really weighty intellectual matters that you might be facing with complex law in extradition cases, and then you've got to put on another hat, which is quite logistical and just not moving paperwork. I don't mean that in a derogatory way. I just mean in a very practical way, in order to make sure that you can see or you can fit in as much useful time within a day.
You are absolutely right. That's a very good term you use, gear change. When you're packed with large numbers of cases to get through in a day, it's really about managing that work. It's about the right people being there at the right time. It's about having your finger on what the real issue is to efficiently get through that work. On the other hand, if you're dealing with a long case, the pace may be very, very different. You may have witnesses across the world on video links. it may be far more geared towards legal argument, and certainly in extradition, a lot of it will be paper based, where you've got written statements which actually go in, whereas in criminal trials, not always so, but a lot of it is about witnesses appearing in front of you. So there is a difference.
And if you were faced with someone for the first time in court, how would you explain to them your role and what's going to happen at the hearing?
Well, I've been privileged in writing something called the Equal Treatment Bench Book, which is available to everyone. It's available on the internet, so you don't have to be a judge to read it. And so I'm acutely conscious of ensuring that the courtroom is an environment where people understand what's going on, where they can participate to the max. A lot of it is just using ordinary English and making sure you get rid of all the sort of Latin and stuff which lawyers can automatically flick into because it's the way they talk. And so often you're saying to people, I'm not sure you got that. The court's a serious place, and these proceedings are serious because they are criminal proceedings. On the other hand, what you don't want to do is make them so frightening that it actually disconnects people from participation.